Hi, Gary DeWaal here, and this is another week of Bridging the Week, August 12th to 16th, and today is August 19th, 2013. Good morning. It was a somewhat slow regulatory news week this week, punctuated by the well-publicized criminal indictment and civil action in the United States against two mid-level employees of JP Morgan related to last year's London whale misvaluation incident. However, before we look at that headline development, let's look at some other important events making up last week's news. It may not seem so important, but it is. Last week, the US CFTC, SEC, and FINRA combined to jointly issue a guidance related to business continuity planning following their survey of financial service industry members impacted by the devastating destruction of Superstorm Sandy in the Northeast United States during October 2012. Although there is nothing really groundbreaking in their recommendations, the guidance reminds firms of the importance of routinely reviewing and updating their business continuity plans, as well as regularly communicating its components to all employees. The guidance also emphasizes the importance of firms ensuring that their critical vendors have adequate business continuity plans too. Other practical suggestions suggested by these regulators included that firms should consider how they will comply with time-sensitive regulatory requirements, such as daily or month-end financial reporting that are obligatory even when firms might be operating in BCP mode, issues that may arise from relying on a single telecommunication service, when such operator may also be detrimentally impacted by the same event causing the firm to operate in BCP mode, and enhancing the capability of staff to work from home when a firm operates in BCP mode. Fortunately, enhanced technology and communications may reduce the need for staff to travel during an extraordinary event when such travel could be dangerous or, at the least, impractical. Although these recommendations are issued to U.S. financial service firms, they clearly have worldwide application. Now here's something that may also not sound too relevant, but it is. Last week, the International Organization of Security Commissioners, or IOSCO, and the Committee on Payment and Settlement Systems, or CPSS, issued a consultative report related to the need for financial market intermediaries to maintain effective recovery plans following events that might jeopardize their viability and financial strength and threaten their ability to provide critical services without the intervention of regulatory authorities. During the same week, the CFTC also issued enhanced risk management standards for systemically important derivatives clearing organizations, a subset of those FMIs. By the way, in case you're not familiar with this acronym, FMI, FMIs are multilateral and centralized systems that perform payment, clearing, settlement, or recurring services, for example, trade repositories, clearinghouses, and securities settlement systems. In the CPSS IOSCO report, for which comments are due by October 11th, the organizations provide an overview of some of the tools that so-called FMIs should include in their recovery plans, including a discussion of events that may trigger the use of such tools. CPSS IOSCO divide these tools into 5 categories, namely tools to allocate uncovered losses caused by a member default, allocate losses not related to a member default, address uncovered liquidity shortfalls, replenish financial resources, and reestablish a match book. The bottom line, according to CPSS IOSCO, is that whatever tools are adopted by FMIs, they must be timely, reliable, and have a strong legal basis, and most importantly, they must be transparent so that those who might have to bear the losses and liquidity shortfalls know in advance how the allocation of losses and shortfalls will play out in a recovery situation. Although CPSS IOSCO emphasized the needs for FMIs that are central clearing counterparties to consider a number of possibilities among their recovery plans, including cash calls on members, initial and variation margin haircutting, which by the way is quite controversial and got a bit of media attention, and forced allocation of contracts, the regulators fairly discussed the downside of employing such possibilities, mainly certain pro-cyclical dangers. It will be up to participants in the industry to help CPSS and IOSCO evaluate these pros and cons, and perhaps offer alternative suggestions. The implications of their final guidance, however, are for sure could have great implications as to the willingness of ultimate customers to embrace more willingly, or not, the central clearing model, as well as of firms to be members of CCPs in the first instance. The CFTC's final risk management standards relate exclusively to a narrow subset of FMIs, namely systemically important derivatives clearing organizations in the United States, of which currently there are only two, the Chicago Mercantile Exchange and ICE Clear Credit. These standards are effective on October 15th and must be complied with by December 31st. In general, the CFTC requires the so-called SITCOs that are involved with a more complex risk profile or that are systemically important in multiple jurisdictions to maintain sufficient resources to meet their financial obligations to their clearing members despite the default of two clearing members creating the largest combined financial exposure, to assess available financial resources to meet their financial obligations in such a scenario without using their assessment powers, and to maintain business continuity plans that enable them to recover their operation and resume daily processing, clearing, and settlement within 2 hours of any disruption. Again, in rejecting the ability of SITCOs to rely on the value of assessments in calculating their financial resources, the CFTC also acknowledged the potential pro-cyclical effects of assessments on members. Again, both the CPSS IOSCO consultative document and the CFTC final risk management standards are important documents worth reviewing and considering, and worth comparing to proposals for recovery and resolution by CCPs that also recently issued by ISDA, the industry organization. As an aside, and also worth considering, are the CFTC proposed rules for designated clearing organizations to align with international standards that also were issued last week. Comments to these proposed rules are due by September 16th. Speaking of the CFTC, this week the Commission adopted final rules related to advisors to certain investment funds that are now permitted to rely on substituted compliance with relevant SEC rules to meet their obligations under similar CFTC rules. This necessity came about because of such advisors' obligation now to register as commodity pool operators under the CFTC regime. I won't discuss this matter in detail because I already have posted a separate article on it on my website. But there are rules in some cases that also benefit ordinary CPOs and CTAs too. Quickly, last week also, FIA, SIFMA, and the Financial Services Roundtable submitted to the CFTC a comment letter related to the Commission's exemptive order that it published as part of its proposed phase-in of its interpretive guidance and policy statement regarding to certain swaps regulations. In this letter, the organizations identify a number of challenging implementation issues, which they argue justify some extended implementation deadlines, as well as a number of technical issues and ambiguities. In Australia, ASIC, the principal Australian futures and securities regulator, announced new high-frequency trading guidance that will be effective as of February 9, 2014. Among other things, as of that day, market participants must consider additional circumstances in considering whether a false or misleading market has been created, the frequency of orders placed, the volume of products of each order, and the extent orders are canceled or amended compared to the number of orders executed. Scott O'Malia, a CFTC commissioner, issued a rare and bitter dissent in connection with the Commission's approval of a Division of Enforcement unnamed investigative order using a so-called absent objection process. He claimed that this process precludes the Commission from independently assessing the facts and legal justifications for initiating enforcement action as required by Congress. At the same time, Commissioner O'Malia called on Congress to conduct a full review of the CFTC's internal policy and procedures for various actions and interpretations of the Commodity Exchange Act. Boy, oh boy, it must be tough to be the lone Republican member of the Commission these days. And finally, last week, the U.S. Attorney for the Southern District of New York filed criminal charges, and the Securities and Exchange Commission filed civil charges in federal court in New York against two former traders of J.P. Morgan in connection with what has become known as the London Whale Incident. Generally, both individuals, Julian Grout and his supervisor, Javier Martin Atajo, are cited for overvaluing certain investments of J.P. Morgan in early 2012 to hide growing losses in such proprietary investments. instead of using a mid-market valuation for the over-the-counter instruments at issue, Grout, in response to demands of his supervisor, Martin Tahoe, used prices evaluation chosen to deliberately minimize an internally reported loss. These prices subsequently were entered into JP Morgan's systems and reported to management so that losses were understated. Although neither JP Morgan nor Bruno Ixel, the so-called actual London whale, were charged in any action, the SEC alleged that during the relevant time, JP Morgan, quote, failed to furnish to the Commission, in accordance with its rules and regulations, such financial reports as the Commission has prescribed, and JP Morgan failed to include, in addition to the information expressly required to be stated in such reports, such further material information as was necessary to make the statements made therein, in light of the circumstances in which they were made, not misleading. End of quote. Boy, why can't charging documents be written in plain English? If, in fact, the U.S. Attorney's Office and the SEC investigated Mr. Ixel and declined to charge him, it's a credit to both organizations that they recognize that, in fact, bad things sometimes happen at firms, despite there being good people at the top of supervisory chains who try to do the right thing. This doesn't mean that supervisors will never be named in enforcement matters, but it means individuals can be saved from enforcement actions if firms have reasonably good policy and procedures, and supervisors follow these procedures and are reasonably proactive too. It may not help JP Morgan itself, however. Indeed, the media suggests the regulatory interest in this matter is far from over, not just in the United States, but in the United Kingdom too. Let's see where it all ends up. Anyway, that's it for now for this week's Bridging the Week. Until next week, Gary DeWaal, have a good week.